So thank you, everybody, and I'm very happy to be here. Glad to see all of you here. Today, we're going to be talking about one of my favorite topics: how to hire, fire, and discipline employees without getting sued. I was telling somebody in preparation for this that this is what my topic was, and apparently he had the magic answer on how to avoid getting sued by your employees. He said, just don't hire them in the first place. Okay, well, that's my whole presentation. So thank you very much. We're going to go over a couple different things today. We're going to be reviewing the policies that all the employers should have. Now, we're going to talk a little bit about which of those policies, when do you have to have these policies, which policies are they writing. We're going to talk about how to implement and enforce the policies that you already have and how to implement it when you're going to bring in new policies. How are you going to implement that for your workforce? We'll be looking at ways to create a positive workforce, positive work environment while still ensuring that everyone gets their work done. We want the work environment to be an enjoyable place, but at the same time, everybody has their jobs to do, and we need them to get that work done. We're going to hopefully be learning effective tools to address those employee work performance issues, disciplinary issues, how to get people to do their jobs without increasing reliability. And we're going to look at some of those common hotspots with leaves of absence. We've been hearing a lot of leaves of absence issues more recently. California just passed the Healthy Workplaces, Healthy Families Act. Well, I should say 2014, but it became effective July 1st, 2015, which requires every employee to be allowed to take a certain amount of paid sick leave every year. Employers that before didn't have to provide any type of paid leave are now having to struggle with the issue of, well, do I have to provide this? When do I not? When is too much leave? When is not too much leave? And finally, we're going to be looking at ways that you can end the employment relationship, hopefully without increasing any reliability. So how can we fire somebody? How can we work towards a mutually agreeable separation, as I like to refer to it? So the first step is what kind of employer policies are we really looking at? Which policies you have to have are going to depend on the number of employees you have applying. There's certain magic numbers that we get out to. There's the 1 to 4 employees. 1 to 4 employees have things like the anti-harassment laws, now the paid sick leave laws, workers' compensation, those types of issues. Once you get up to 5 employees, that's when the Fair Employment Housing Act kicks in and you have obligations for anti-discrimination. You can't discriminate against somebody based on age, race, national origin, etc. Also, that's when the disability accommodation requirements come in. So if somebody has a medical issue that qualifies as a disability, you may have to provide some type of an accommodation. 15 to 24 employees, there's a few additional leave laws that are going to apply. Same with 25 to 49, we got a few more leave laws that are going to apply. 50 is really kind of a big number because that's when the Family Medical Leave Act kicks in. If you have 50 or more employees working within a 75-mile radius, you have to provide up to 12 weeks of unpaid leave for certain serious or chronic medical conditions or family issues. And then 100 or plus employees, which we're really not going to touch on. The main issue that comes up with 100 plus more is when you go through a layoff and you have to go through. Law assumes anybody doing work is your employee. There are certain people that can qualify as an independent contractor, but the burden is on the employer to establish that this worker really is an independent contractor, not an employee. And there's a lot of different factors that the courts look at in the different agencies. In fact, the rules are different for the IRS versus the Employment Development Department versus workers' compensation versus common law versus federal law. So there's not one set of tests that says this is applicable to all employees. What I can tell you is here in California, if you control the hours, the wages, or the working conditions of the worker, California is going to assume you are the employer. It's not an independent contractor relationship. There's a lot of different factors. One major factor is the level of control. If it's an employee, you typically have the ability to control the manner and means that the work is performed. If it's an independent contractor, it's up to them to decide. A good example is I'm an attorney. If you hire me, you're not in the business of practicing law. You're hiring me for a specific project to advise you. It's not part of your normal business. Of course, I'm an independent contractor. Well, what if you hire somebody to provide just HR consulting? Well, if it's a regular part of your business, that person could end up being an employee if you're their sole client. They're only providing services to you. They don't offer their services to other people. But there are HR consultants that service a wide number of clients. In the care industry, when we're talking, say, caregivers, because I deal a lot with caregivers and families that are hiring caregivers, a lot of people want to hire them as independent contractors. And the reality is, I have yet to see a situation where you can have a caregiver who is an independent contractor, particularly if you have that caregiver providing services just, I'm the only client, I'm the only person that the caregiver serves. If it's somebody who really has a business license, preferably a corporation or an LLC, they advertise and provide their services to a wide variety of people. It's on a temporary basis. Okay, I just need somebody this weekend because my caregiver is sick, and this is a company, this is somebody that offers their services to a lot of people. I could see that possibly being an independent contractor situation. But the default in California is the person is going to be an employee unless you can prove that, no, this person has a separate business. They're offering their services to other people. I'm not controlling how they're doing their work. And to make things even more confusing, the legislature in 2014 passed a law that became effective January 1, 2015, to combat the situation where you have a lot of third-party employers that will provide employees to big companies, Cisco, Apple, and small companies. And what was happening is employee will be an employee of company A. Well, company A sends the employee to company B, who sends it to company C, who eventually is doing the work for company D. And the employee doesn't always get paid what they're supposed to. They get injured. And the original employer that hired them didn't have workers' compensation insurance or was not paying wages. So the legislature changed the law and said, if you are anywhere in that chain of employment, you can be liable as the employer. Now, there is an out. It only applies if you have 25 or more people working on your payroll like that. So it's not a situation most of you are going to encounter, but it is a concern. There are some care agencies that might get their caregivers through other agencies, other placement agencies. And the reality is everybody could be considered an employer. So I have a number of policies that I generally recommend employers have. This doesn't mean you have to have all of them. Some of them may not be appropriate, but really, even if you have as little as 3 or 4 or 5 employees, I do recommend there be some sort of a handbook, some collection of policies that has many of these policies in them. If you have only 1 employee, do you really have to have a handbook? You don't have to. But as we go on today, we're going to be discussing the importance of having something in writing. If you have an internal complaint review procedure where somebody, if they want to make a complaint, they need to know who to go to. If it's not in writing and that employee never uses that complaint procedure, you have no way of saying, well, hey, look, we have a procedure in place. Now, I have identified those that I really think are the very most important policies. An equal employment opportunity policy, I think, regardless of whether you have 1 employee or multiple employees, something that says we don't discriminate on the basis of age, race, sex, national origin. Now, every year the legislature is expanding that list. Every year we kind of have to update it. You always want to have that kind of catchphrase in there. It says, or any other basis prohibited by state, federal, or local. Employment at will is one of the most important policies. And it's actually a policy that I recommend every employee should sign. Now, that employment at will policy might be signed as part of an offer letter or employment contract. If you have an employee handbook, if you hire somebody to prepare your handbook, or if you've seen handbooks, oftentimes the last page is a confirmation of receipt saying, yes, I've received the handbook, and it usually has the at will language in it. At will is the default in California. What that means is I can fire somebody for absolutely no reason at any time. There are limits on that. We're going to talk a little bit about what some of those limits are in a little bit. But there were a whole host of cases, primarily back in the 80s and the early 90s, that held that even though the standard is that, well, you can fire somebody for no reason, employees who have been employed for a long time, if there's this implied agreement that you can't fire somebody unless you have good cause, that can create what's called an implied contract. And now you may not be able to fire that person for any reason or no reason. Now, as a matter of practice, and we'll talk about this in a little bit, I'd never recommend firing somebody for no reason. This is not the Drew Carey show. People don't show up saying, you're doing a great job, you're fired, have a nice day, here's your last check. There's always going to be a reason. But we still want it clearly. Usually the handbooks I create have in about 2 or 3 different places saying you're an at-will employee, you can be fired at any time. The policy against harassment is one of the other policies, particularly if you have 2 or more employees. Really, having an anti-harassment policy when it's just you and one other employee is a little difficult, because if you're harassing the employee, who are they going to complain to? If you have 2 or more employees, absolutely you want to have an anti-harassment policy. It is illegal, even if I only have 1 employee, although I can discriminate against somebody on the basis of age, race, and color. If I don't have 5 or more employees, I cannot harass them because of any of those protected reasons, even if I just have 1 employee. Couple things in the anti-harassment. One is, you want to say what type of activity is prohibited. Pretty simple. You can't use derogatory terms. There's a lot of language out there, but also what is going to happen, if somebody has a complaint, what are they supposed to do? If instead of just keeping it to themselves or lashing out, have a complaint procedure. If you have an issue, bring it up to me. We'll talk about it and we'll get it resolved. I also recommend employers have meal and rest break policies in writing, in their handbook. Every employer is supposed to have in the workplace certain workplace posters. You've probably gotten them in your Staples or Office Depot or AEP or any number of Costco nowadays. Those posters usually don't include the wage order. A wage order is a set of regulations that every employer is supposed to have posted. Depending on which type of business you're in, is going to alter what poster goes up. But it has what the requirements are for meal and rest break periods. So you literally can cut and paste it from there, put it as a separate policy or as part of your handbook. And the reason the meal and rest break policies are so important is, in the past 7 or 8 years, I have not had a lawsuit yet that did not include a missed meal or rest break policy. The law requires every employee to receive a half-hour lunch break whenever they work more than 2 10-minute rest breaks in a normal 8-hour day. If the employee doesn't get those breaks, then you have to pay a penalty equal to 1 hour's wage. And you would be amazed at how many disgruntled employees, for whatever reason, come back and say, "Oh, I never got my rest break. I never got my meal break." And there are some things in the caregiver industry. There are actually some exceptions that we can use, and in different types of occupations, like gas station attendants, where somebody's the only person on duty, you can have what's called an on-duty meal agreement. But we want that in writing, because if you get brought to the labor commissioner, the first thing they're going to ask is, what does your policy say? And if you have a policy that says you need to take these meals and rest breaks, it's much harder for the employee to say, "I didn't know I could take these meal and rest breaks." So that's another one that not only do I want the policy, I like it when the employees sign that policy, and preferably policy also says that employees will keep track of all of their hours. Now that we have the Healthy Workplaces, Healthy Families Act, every employer is supposed to have a sick leave or paid time off policy. Pretty historic in the sense that this is the first one of the first states. There's a couple others that have paid sick leave policies, but there's a big push for this now. Now, in certain cities like San Francisco, Emeryville, Oakland, San Diego, and there might be a couple others, they have their own paid sick leave ordinance. But this is really the only time that the laws requiring paid sick leave for all employees, regardless of whether you have 1 employee. And employers can choose how they're going to provide that paid sick leave to some extent. They can either say, what the law says is every employee is supposed to get 24 hours of paid sick leave per year. And they can either accrue that, so they get 1 hour of paid sick leave for every 30 hours worked, and they accrue it until they get up to 48 hours, even though they can only use 24 in a year. Or you can just say you get 24 hours per year. And a lot of employers have been struggling to get those policies in place. How do we want to have it accrue? How do we not want it accrue? And if you have any employees that are working in one of those cities like San Francisco, Oakland, Emeryville, they have even higher requirements, and you have to comply with both the state and the local. I have some clients that have employees in Oakland, Emeryville, San Jose, all these different places, and they're trying to figure out how we would apply. Because San Francisco requires the employer to provide up to 72 hours of paid sick leave per year. For a small employer that's struggling, that can oftentimes be difficult. Policy should be erratic, and it's actually, there is a poster that you can put for paid sick leave. If you already offer paid time off, do you have to offer paid sick leave? As long as your PTO policy meets the minimum requirements of the paid sick leave policy, you can use your paid time off policy, your PTO policy, to satisfy the paid sick leave. The problem is, most people say, "Oh, I give 1 week per year. I give 5 days, 40 hours a year for PTO." The paid sick leave always says I have to give 24 hours. We're good. That's actually not true. And the reason is Paid sick leave requires the employee to accrue, either you give them the 24 hours up front or they have to accrue it at a 30-to-1 ratio. For every 30 hours worked, I get 1 hour of paid sick leave. That actually works out to just over 8 hours or 8 days per year if they accrued it all throughout the year. So if your paid time off only gives them 40 hours and they're accruing that over the full year, that's actually a lower accrual rate than the 30-to-1 that's required by the paid sick leave. So it's something you want to look at to make sure, are we applying this correctly? Now, there are some people that think you should not use paid time off for paid sick leave, that you should have vacation and paid sick leave. And their rationale is, I think it applies to more larger employers, because there's all these different unpaid leaves of absences under the Family Medical Leave Act and stuff. There can be problems between the two. I think I've been able to successfully integrate the paid sick leave and the paid time off in most instances. So most times we can get away with that. Depending on your business, I'm a big fan of the technology use and security. What that says is, if you were using, we're going to give you an email or access to a computer. Anytime you have employees that are going to have access to a computer or be using a work computer for work email, I want a policy that says, look, this is my stuff. I'm going to search. I have the right to search your emails. I have the right to search your computers. You can't put passwords on there. You can't download programs without my authorization. And this is for your protection. There were some cases where an employee was using the employer's computer systems for things they weren't supposed to, going to websites they weren't supposed to. Employer searched through the computer, found out about it, fired the employee, and the employee sued the employer for an invasion of the employee's privacy. And the court didn't dismiss the case, indicating that there's at least a possibility that if everybody has a reasonable expectation of privacy. I have an expectation that you're not going to barge into my home and start rifling through my stuff. Well, that right to privacy actually carries over into the workplace. And if I have a policy that clearly tells the employee, hey, look, I'm going to be looking through your stuff, it diminishes that expectation of privacy. It eliminates the possibility that they're going to come after. It also sets it up in people's minds that, oh, okay, they may be looking at this. Maybe I should go visit that particular website on my work. It also will enable us, when you have that employee who's spending a lot of their time on Facebook, you can point to, hey, look, our policies say you're supposed to be using computers for work purposes only. I mentioned before that most handbooks should all have an acknowledgement of a receipt. If you have a handbook and it's a great handbook, has all your policies, but you have no proof that your employee ever got it, it doesn't do you any good. The whole reason we have the handbook is so the employees can presumably look at them and have a resource to go to. Question is, if you have a full-time hourly employee, are they entitled to holidays? No, not yet. There is a bill pending in the legislature. I don't think it's going to pass this year. That's going to require double time pay for certain specified holidays. But as it is right now, you do not have to pay employees extra for holidays. You don't have to pay them extra for weekends. But if your handbook says, we follow all these holidays, then yes, you do have to comply with that. And there are different ways to handle holidays. Some employers say, regardless of whether you work or not, we're going to pay you for 8 hours. Others say, we're only going to pay you if you work, and we're going to pay you time and a half if you work, or we're only going to pay you if you work the day after. So you can define that as you want. Some of the optional policies that you may or may not want to have. And again, the more employees you have, the more likely you're going to have some of these other policies. I'm not going to go through all of them. I think some of the more important ones are the personnel records. The law was passed 2 years ago that all employees have a right to access their own personnel records and to receive a copy of those personnel records. It used to be you only have to provide them anything that they signed. Now, anything that's part of their personnel file, they have a right to get a copy of. So if you have particular procedures you want them to use, then you certainly want to use that. Things like proof of right to work, conflicts of interest, those are going to depend on what your work style is. I do recommend the use of offer letters at the very least, preferably employment agreements. Oftentimes, the offer letters that I draft up usually tell employees this offer is contingent on you being able to prove that you're eligible to work in the United States. Or if I'm going to do background checks, you have to successfully complete the background check. The real purpose of an offer letter is to set down those real basic things of how much are we paying you? Are you getting any kind of benefits? When is your employment going to start? And you may think, well, I don't really need this. I had a client that had a landscaping business that used offer letters, even though nobody else in his industry did. And it really came in handy when he had one time he went and found a day laborer just to help him out to do some work at my client's home. And a year and a half later, that employee came back claiming he had been working for my client in the landscaping business for about 2 years. When in fact, he worked one day at my guy's home and he paid him for that day and never did any other work. Since we were able to show that here's all the offer letters we have for all of our employees, and we don't have one for this guy. Here's all the I-9s that we have for everybody. We were able to show that this person actually never did work for us. And one of the ways it helped us prove that this person never actually did any work for us. I want to talk a little bit about performance evaluation. How many of you out there who have employees have ever used a performance evaluation? How many of you ever received a performance evaluation at any point in time in your career? I'm a big fan of performance evaluations. I think that it's time to sit down with the employee, talk about what your expectations are now, where are they with respect to how they perform. If you're not currently using a performance evaluation process, what do we want to include in there? The main focus is what you expect. And I have clients that say, "Oh, Rob, can you do create a performance evaluation for me?" Absolutely, I can do that, but I need to know from you, what is it you expect your employees to do? Do you want to focus on servicing the customer? Do you want them answering phone calls quickly? What are the things that are most important for these positions? And you may have a different performance evaluation for different positions. My preference is to have one if you have a lot of different types of employees, have one performance evaluation that can focus on the different areas that are important throughout the organization. The performance evaluation provides you an opportunity to review with the employee on how you perceive how that employee is doing, and for that employee to communicate to you how they perceive how they're doing. Oftentimes, there's a big disconnect between what you perceive and what they perceive. And the performance evaluation is that opportunity to sit down and say, this is where you are, and this is where we want you to be in the future. You're looking at not just mistakes, you're looking at also those strengths. I was going through my Twitter feed on the way, and there's a really nice article about the importance of communication in the workplace. And like out of 1,000 people, 69% of them, their number one complaint about the workplace was the lack of communication, that my boss isn't telling me when I'm doing something right or when I'm doing something wrong. If you only tell employees when they're doing something wrong, well, that's going to create a different relationship than when you're giving them more balance of, hey, you did this right. It's kind of the carrot and the stick perspective. And the performance evaluations should not just be looking backwards to how they were doing, but also looking forward. How are they doing in the future? What things do we expect them to do? If we've had some areas where they've struggled in the past, how are we going to improve those going forward? Are there new areas that we want them to go into? Maybe now we want the employee to take on more marketing responsibilities or more administrative tasks, whatever it happens to be. The performance evaluation is a great time to be able to put that in there. As far as the format, I really don't care what kind of format it is. They can be informal, they can be formal. I prefer them to be in writing because if there are problems later on down the road, it's nice to be able to go back and say, see, we talked about this in your performance evaluation 6 months ago, and this is happening again. But I've seen some that are as simple as you sit down, you have a conversation, and afterwards you write a note saying, hey, this is what we talked about. I'd rather have, I like notes, and I like when you have like a scale 1 to 5 or something like that. And I also like it when you actually review the job description. I'm surprised how many people don't have job descriptions. And I guess I should be surprised. I mean, we're focused on getting the work done. We may not be necessarily paying attention to, well, do we really have to write out what somebody does on a day-to-day basis? My answer is yes. And there's a number of different reasons I want to have a job description. Number one is for the performance evaluation. If you don't have something in writing telling them what they're supposed to be doing, how are they going to be able to measure, are we living up to those standards? Number two, if an employee ever needs any type of a job modification as a result of a disability or a religious accommodation, knowing what the job description is, having that job description in writing makes a big difference in determining what kind of modifications can or cannot be done. If, for example, I have a caregiver and I haven't identified the fact that lifting a 125-pound person is an essential portion of the job, and now that person hurts themselves, I may have a more difficult time establishing that, look, you can't do this job unless you can fulfill this physical. They should always act, if you're going to have it in writing, it is something that they should sign, even if you're not asking them to sign acknowledging that it's accurate, at least having them acknowledge that they received it. I mentioned that I like using a scale. Just having 1 to 5 doesn't do you very much unless you really kind of define what that means. And it could be 1 to 5. It could be, failing to meet expectation, usually meets expectations, always meets expectations. It could be whatever scale you want, but people are along the continuum. Again, I like the self-evaluations to help to see if there are any kind of disconnects between how you're observing them and how the employee is observing them. If you're in a larger organization, I also think particularly if you have managers or overseeing other people, I think it makes sense to get a 360 evaluation and get a review from the subordinates on how is the manager doing. You may have a great employee that was working for you for a long time, and so you elevate them to a managerial role, only to realize that, okay, this person is a great employee, but maybe not such a great manager, or could be a great manager if we teach them some additional communication skills and tell them to stop throwing things at people. And I also like to ask, is there anything that we can do to improve? This is not just an opportunity for you to evaluate the employee. It's an opportunity for you to get feedback on what things need to be done differently. But some of the best ideas come from our employees. We may not, they're, especially if they're the ones in the nitty gritty, they're doing the day-to-day tasks, they may have more efficient or ways of doing things. How often do you do a performance evaluation? Again, this really depends on your organization. I think the bigger the organization, the more frequently you're going to do it. Certainly after the first 90 days is an appropriate time, or at least the first 6 months. And that first 90 days is really that introductory period. I know a lot of people say probationary period. I hate that phrase, probationary period. And any of my clients that have that in their handbook, I take it out. And the reason is I don't want people to expect that, oh, I've passed the 90 days, so now I'm no longer an at-will employee. No, you're always an at-will employee. But it is important after the first 3, 4, 5, 6 months to sit down and say, how are things going? What areas are you struggling in? What areas are going well? Are you ready to take on additional responsibilities? And then if you do it every year after that, is fine. Doing them every 2 years is, I think, a little far. But one thing that's really important is there should never be a surprise in a performance evaluation. If there's a problem with behavior or performance, that's something that should be addressed at the time. The annual performance evaluation is the time to review those things. If an employee walks into a performance evaluation and for the first time they're hearing that they're not doing their job very well, they're going to think that they're being treated unfairly. And I can tell you the number one reason that employers get sued isn't because the employers violated the law. It's because the employee believes that they're being treated unfairly. Open communication, telling them when there's an issue will go a long way to resolving those disputes. My performance evaluations in the handbook, they always say if we do a performance evaluation, it's not a guarantee of a raise. I do think if an employee is asking for a raise, then you should do a performance evaluation. You should sit down and say, okay, well, if you want a raise, let's talk about it. What have you been doing? Where are we going? If you just want to do a cost of living increase for everybody across the board, okay. My preference is, well, let's sit down and actually review how you're doing in your performance. Because ignoring the problem doesn't make it go away. I've tried it. Try it with my children. It doesn't work. I try it with my wife. It doesn't work. And it has other problems. Number one, it can lower the morale of the office, not just of the employee. Anytime there's conflict, your employee's not doing what they're supposed to be doing, you're going to be upset. You're going to take that out on the employee. Other employees are having to pull up the weight for the other person. They see that, well, this employee is able to leave 15 minutes earlier or is always 10 minutes late and nothing happens to them. Well, why can't I do it? End up with lower productivity. You're not getting more paying money for these people to do work. If they're not doing the work that you expect them to perform, then you're paying money then you're not getting the benefit of your bargain. And eventually it's going to end up in the loss of an employee. And it may be because you have to fire the employee because they're not performing well, or you're just sick and tired of complaining, or whatever happens to be, or that employee is just dissatisfied with it. I did an interview recently with a workplace mediator, and he was telling me about a statistic. He specializes in coming into workplaces when there is a dispute. and sitting the parties down and trying to help them come to a resolution. And he quoted me a statistic that it's about 150% of a person's annual salary to replace that person. And that percentage actually increases the more that person makes. Because you figure you've got to now advertise for somebody else. You've got to spend time interviewing those people, find the right person and hire them. Maybe bring in an HR person. You've got to get them oriented. You've got to do all the training to get them up to speed. They're going to be slower doing their job at the beginning. When you add up all those costs, it's not as simple as just, okay, I'm going to get rid of this person. Now, there are some jobs. I mean, if I'm flipping burgers at McDonald's, I don't think it's going to cost me 150% to find somebody else that's going to flip burgers. Certainly the more complicated tasks are, the more costly it is. Discusses how do we discipline these things, discipline employees without getting sued. Talking with people up front when there's an issue, addressing it in a responsible manner is going to avoid that lawsuit, because the employee is going to be much less likely to go see an attorney, complain about you to other people. I used to represent primarily employees. I now represent probably more employers, but I still represent some employees. And every single time the employee is coming in because they're upset at how they were treated. I had one client who didn't like the fact that he was fired. He thought it was a racial termination because he was in charge of the entertainment for the corporate annual meeting. And his culture, belly dancing was good. Well, the Japanese owners of the company didn't think that having a belly dancer was good, and so they fired him. And he said, well, hey, this is race discrimination as part of my culture. And I had to let him know that's not the case at all. But in going through his facts, I realized that he's working 10, 12 hours a day. And although he was called an executive director, he was actually cooking the meals, hanging up signs, he's cleaning the bathrooms. He's spending most of his time doing what we call non-exempt work. Well, under the law, he should have been paid overtime for all that time. So although he did not have a wrongful termination, he did have a $150,000 overtime claim. And that if the employer had treated the employee differently, he never would have come to see me. He probably continued to work there for years and not have any other problems. Whenever a problem comes up, you guys get to play the adult. If you're the manager, you're the supervisor, you're the owner, you guys get to play the adult. You have to always act in a professional manner, no matter how outrageous the employee might be acting. Your job is to be the responsible person, be the adult in there. Waiting until an employee tells you, that, oh, I need to take some time off because, I'm going in for surgery. That's not the right time to all of a sudden bring up the past 6 months worth of grievances. It's common to want to be able to ignore it. No, okay, this is not that big a deal. Okay, I'll just pick up this work. I'll get it, or I'll let somebody else do it. By doing that, you're creating a snowball effect such that when enough is enough, it may be too late because that employee may have already engaged in some type of protected activity. Again, we're going to talk about some of those hot spots for protected activity. As a colleague of mine gave this to me, and I've been using it with all my clients. It's a constructive feedback tool that I use. It has several different parts: observation, impact, check, suggestion, alternatives, arraignment, consequences. This is kind of a process that I try to get my clients to go through whenever they have a problem. But it could be a disciplinary issue because somebody has done something wrong, a performance issue, performance appraisal, or performance review. And this is a 7-step process to go through it. So it starts with the observation. The observation is you're observing without judgment. You're just describing what the behavior is. You said X. You talked to when you answered the phone, you answered, hey, what's up? Those are facts. You really want to avoid opinions. For example, you were rude. That's a conclusion. That's an opinion versus saying you raised your voice to the client and you hung up the phone without saying goodbye. Those are all facts. Stick with the facts. Keep out the colored commentary. In general, I'm also a de minimis, even though anybody who's talked with me knows that I like to talk a lot. My actual advice is when you're disciplining employers or going over performance issues, less is more. You want to stick to the facts. Usually doesn't require an inordinate amount of. After the observation, you want to talk about the impact. It's really cause and effect. When you did this, this is what happened. How were other people handled? This was, I learned back when I was a psych major. when you yelled at me, I really felt belittled. That kind of a communication in the employment situation, it might be when you hung up on when you hung up the phone without saying goodbye, you made that client think that you weren't paying attention, or you didn't have the opportunity to find out if the client was really done with that conversation. Or when you show up late, when you show up 15 minutes late, that means there's somebody not here answering the phone, or somebody else has to show up to take care of, do your job. Or when you don't get your work done on time, when you don't get your project done, that's going to delay X, Y, and Z. So we start with the observation, and then we move into what is the impact, what's the cause and the effect. And then I like to check. The check is what I'm getting them to understand. You remember when you did that. So you came in late to work 3 times this week. You remember that? Yeah. Yeah. Do you see how that could be a problem? When if it's a client problem, or they interacted with another employee, they got to an argument. Is there? Do you see what the impact of your action? What was your part of it? Where you're getting them to at least acknowledge, yes, there was an issue here. Doesn't mean they're necessarily going to agree that they were to blame. Psychologically speaking, I am never to blame. And that's how most people are. We rarely can see our own faults. We always see in other people. So you're not necessarily trying to, you're forcing them to agree, but at least to agree with this X happened and Y was the result. Then we want to come up with a suggestion. Okay, now that we've identified that there's this problem, what are we going to do from here? And I always like that to come from the employee first. I've sometimes been surprised when an employee will come up with a solution that I never thought. Now, I always have my own solution in mind anyways, because the next step is going to be talking about alternatives. But if the employee can come up with that solution, then they're going to have more ownership in the solution. So different ways to say that. What would you have done differently? How could we have handled this in the future? What do you think are some different ways to do this? And then is when, if they haven't come up with a good solution, that's when we may need to provide our own alternatives. Okay. Okay. Well, instead of, I understand you had your car broke down. What can we do? Maybe you need to leave that, or there was a big accident on the freeway. What can we do differently? Maybe you need to leave the office 10 minutes early, or leave your house 10 minutes early. Again, I like to have some suggestions or alternatives available when I'm going in to have that conversation. And the more you use this tool, the more kind of natural it becomes. And then we're going to have an agreement. We need to have them understand that these are the new expectations from this point forward. Oh, you have to be here at 9 a.m. period. And can we agree to do that? Yes, we can agree to do that. Do you have to put that in writing? That depends on the seriousness. If it's something that has happened repeatedly, then yes, it's something we're going to be putting in writing. If this is something that we think we can handle with just a discussion, maybe we don't have to have them sign a document, but maybe we do a lot on it. Well, we're setting those expectations so that if they don't do it again in the future, we have something we can fall back on. We just had this conversation. And then the final step is the consequences. There should be consequences when an employee doesn't perform up to standards, when they don't, when they make a mistake. Again, if it's an early on, if this is the first time somebody's done something wrong, maybe you don't have to have severe consequences. By the way, these consequences part, I've used this tool with my family. That consequences part fails with my wife at the time. Just not able to implement those like that. I start with, if this happens again, she just looks at me, yeah, what? I'm forward. What's going to happen next time? Are we going to have another discussion? Are we going to have a written warning? Are we going to suspend the employee? What's going to be the consequences if this type of conduct occurs again? One of the keys when you're disciplining employees or when you're having policies is consistency. Consistency. Treating different people differently leads them to believe that, well, why are you treating me different? And even though you may have a very good reason, I'm treating you differently because, well, this is my daughter and I'm going to treat my daughter better. That makes absolute sense. But if the other person feels that you're treating them differently because of their age, race, sex, national origin, or one of the other 15 different reasons, or because they complained about a violation of the law or something like that, now you're looking at a possible retaliation. Again, both lawsuits come out of an employee believing that he or she was treated unfairly. And when you have different rules for different people, it creates an atmosphere of distrust. They don't know what the expectations are because the expectations for one is different than the other. And most importantly, from my perspective, because I'm an employment attorney, it is one of the ways that an employee can prove discrimination. If employee X is allowed to show up 15 minutes late and doesn't get written up, but employee Y gets written up whenever she's 15 minutes late, well, that employee could say, oh, it's because of my age or my race or my sex or my national origin, and point to the fact that I'm being treated differently than this person who's outside of my protected characteristics. To the extent possible, treat like situations alike, but not every situation is identical. There are going to be different reasons. If I'm late because my car broke down, this is an isolated instance. That's a much different situation than somebody who's habitually late. And that's, again, one of the reasons why we have those handbooks. Why I would start off with we should have written policies is that can help us establish the consistency. Is there a question whether or not this is how they're supposed to be doing things? What does the handbook say? When to document issues. My goal is not to have you spending your entire workday nitpicking and documenting every little right and wrong. Most things can be handled with just having a conversation. Hey, when you did X, that didn't work out so well. Let's do it different. And in most situations, that's going to resolve it. But some of the things that in my opinion, require documentation, employee contracts. I've mentioned that the employee offer letters, the contracts when they're being employed. What are their pay rates? You'd be surprised how many times I've had an employee bringing claims saying, "Oh, I was promised X dollars an hour, and they only paid me Y." Well, you were paid Y the whole time. What made you think you were going to get X? Because that's what they told me. Well, we didn't have anything in writing, and the labor commissioner takes the position that, well, if you agreed to pay them $12 an hour, at least until they got that first paycheck, you should have paid them $12 an hour. Any changes in the compensation plans? If you have commissioned salespeople, one, the law requires you to have the commission agreement in writing, but if there's ever going to be any modification to that, if you're changing somebody's hourly rate, I don't care if it's a raise, if it's a decrease, if you're adding benefits, if they're now going to get participating in the 401k, whatever it is, any of those changes in the compensation plan should be documented. If there's going to be any job duty changes, even sometimes if it's going to be a temporary, Bob is going to be out of the office for 3 months. So for the next 3 months, I need you to take over these job duties. I'm going to have that in writing. It could be as simple as an email saying, hey, this is what you're going to be doing for the next 3 months. Or at least we're going to have a verbal communication, and I'm going to have a note that if there's any special arrangements with employees. Okay, our work hours are normally 9 to 5. This employee, we're going to let work from 9:30 to 5:30. Again, any deviations from the standard policies should be in writing. Work from home. Sometimes some people allow their employees to work from home. If you're going to allow the employee to work from home, I do think you should have that in writing because you are creating that as a work environment. Now, if they fall and get injured while they're sitting in their chair at home, it becomes a workers' comp issue. Or if they happen to be smoking in their house next to an open can of gasoline and they blow up, that could be problems. Most employer policies say you can't work overtime without permission. Well, then that means if you were going to ask somebody to work overtime, you should put that in writing to them that, hey, I need you to put in a couple extra hours. The benefit of doing that is if somebody later claims, oh, I worked overtime, but you have the history of, well, anytime I have you work overtime, I put in this request and we don't have a request for this time, I can help prove that no, they didn't actually work that overtime. Now, hopefully, I guess I should have put that in here. You are keeping track of the hours your employees work. For hourly employees, always, they need to keep track of the hours that they work. Starting in the shift, when they start their lunch break, when they get back from their lunch break, when they clock out for the end of the day. Now with the paid sick leave, even for some salaried employees, it may make sense to be tracking the hours that they work. I do a lot of work with wage and hour issues, and one of the big issues is whether or not somebody is entitled to overtime or not. Many people think that if you pay somebody a salary, that means you don't have to pay them overtime. That is not true. That's only part of it. They also have to be spending most of their time actually performing exempt duties. And if they don't meet both the salary and the duties test, you have to pay them overtime. And an employee client that worked for a law office and was paid hourly for years until the employer was tired of paying her overtime, so they decided to pay her a salary. But they still had her doing the same amount of work, same type of work, and they just didn't pay her any overtime. And as a result, we took them to the labor commissioner. They had to write her a check for $160,000. And because the employer didn't have a record of the hours that she worked, the hours my client said she worked were the hours that the labor commissioner awarded. because the burden is on the employer then to prove that what the actual hours are. So always keep track of the hours that people work. Anytime an employee asks for an accommodation for workplace adjustment, those should be documented. A workplace accommodation can come in many forms. If you have 5 or more employees, you have an obligation to provide a reasonable accommodation of persons with disabilities or persons who need accommodations as a result of religious reasons. Some of you may have heard there was that county clerk over there and who didn't want to issue marriage licenses because it was against her religious beliefs. So somebody asked me, well, why can't they just fire her? Well, number one, she's an elected official. They can impeach her, but they can't fire her. But even if it was a private employer, the employer would have to consider the fact that this person has a religious belief, and we have an obligation in California federal law to accommodate those religious beliefs. And we may need to look at the things that we can do to modify the job. More commonly, we'll see it with headdresses, and companies will say, you have to wear our hat. And the employee says, no, I have to wear my religious head covering. It disputes someone there. But any kind of modifications to the workplace, if they have a disability and I need a temporary leave of absence, or I need to work a modified work schedule, or I need to work from home, those should be documented. My preference is I have what I call a disability accommodation worksheet that anytime an employee asks for an accommodation, we give him this accommodation worksheet that the doctor can fill out. Does not require the employee or the doctor to reveal what the medical condition is, because believe it or not, although you have to accommodate the disability, you cannot ask what the disability is. Anytime if an employee needs an accommodation for a medical reason, we need to explore, is that something we can do? And it starts off by finding out, well, what is the accommodation you need? Is that something we can do? This disability accommodation worksheet that I've created gets that information. What are the limitations that you have? What are the modifications that you need so that we can evaluate, can we do it? Because you don't have to do every modification. An employee may, I need to be able to leave of absence for 1.5 years. Well, I can't afford to have you not doing your work for 1.5 years, so no, that's not going to work. Or I need to be able to work from home. Well, no, I need you to answer the phones. There's not a way for you to do that from home. So, but this disability accommodation worksheet can help us flesh out what is the accommodations that we can and we cannot do. Anytime there's a request to make up time for time off, there's a concept in California that you can have. It's called makeup time. Where if I have an hourly employee, say a normal office employee, they work over 8 hours, I have to pay them overtime. But they come to me and say, hey, look, Friday, I need to leave 3 hours early because I got a doctor's appointment. Can I work an extra hour on Monday, Tuesday, and Wednesday? We work 9 hours just those days to make up the time. And you can agree to that. And as long as they're doing that work within the same work week and it's in writing, you don't have to pay them overtime for the extra hour they worked on Monday, Tuesday, and Wednesday. But it has to be in writing and it has to be within the same work week. So there are certain restrictions on it. If any of those requests to work extra time or change their job work schedule should be in writing. We already talked about conduct. And first time an issue comes up, an employee is complaining, somebody comes to me, oh, Alex is really bothering me. He's yelling, screaming, and I can't stand working around him. Find out what that's all about. Have the conversation with Alex. Talk about what's the appropriate behavior. And then we move on. If it comes up again, okay, now we got to do it a little bit more seriously. And we had this conversation before. You agreed you were not going to throw Nerf footballs at your coworkers anymore. If this happens again, you're fired. We're increasing those consequences. There's a concept called progressive discipline. If you have a handbook, you had it done by an outside source, chances are they have a section in there about progressive discipline. I hate the phrase progressive discipline because it gives the impression that you as the employer have to follow this progression. You're going to give me a verbal warning, then a written warning, and then maybe a second written warning, then a suspension, and then the performance improvement planning. No, the law doesn't require you to have any specific progression that you go through. Now, as a practice, I'm a firm believer in progressive discipline, and I think you should practice progressive discipline. You should, start small and work your way up. But I always refer in my handbooks to corrective action, and I make it clear. We may start with a written warning. We may start with a termination. It depends on the severity of the conduct. Again, smaller employers, it's easier to be consistent. With larger employers, I understand why they want to have it. You have to go through this process to ensure that they have that consistency. When do we want to document things? Again, Don't wait for the annual performance review. If you're waiting for the annual performance review to address an issue, it's too late. Now, again, if the performance review is going to be next week and an issue came out today, that's a performance issue. Okay, maybe we can put that off. But if somebody's not performing up to standards, have that conversation with them, because sometimes they don't know that they're not performing up to standards. The closer to the event is better. But I warn, don't do things in the heat of the moment. I have a tendency sometimes to yell and scream, particularly like children. And I'm learning that if I even just take 5 or 10 minutes between what they did that really angered me and when I had a conversation with them, I can be much more rational. Because again, for my employees, I'm the one who has to be the adult. I'm the one who needs that responsibility. Now, there are times when you need to stop something right away. You may need to say, stop, this is not acceptable. Maybe send somebody home, maybe tell them to go take a walk around the block, whatever it happens to be, particularly if there's any voices are being raised or people are any threats of violence. Absolutely, you have to take some sort of action right away. If something happens on more than one occasion, that's absolutely something that should be in writing. If you call me up and say, Rob, I want to fire Janet. Okay, great. Why do you want to fire Janet? Well, Janet's not doing her job. She's doing this and she's doing all these things. Okay, well, then why aren't you firing? Well, she did recently say she got injured on the job. Okay, well, let's take a look. Why don't you send me over where you documented all these performance issues you were talking about? Oh, well, I don't really. Oh, okay, well, how about your notes on when you had the conversation? Well, I haven't really addressed with Janet these issues yet. Well, now we got a problem because we don't have the documentation to show that this has been a repeating problem. And I'm going to tell you, if you fire this person, you're likely going to end up with a lawsuit of some sort, because from the employee's perspective, everything was going along fine. And again, it is surprising. I guess it isn't surprising, but it happens so frequently that employees have a different perspective on how they're performing compared to how to document things. Again, it's just going to depend on your organization. Do we do just a personal note? Do we do a formal writing? Things that are more serious require something that's going to be in writing. Things that are smaller, not necessarily. If they happen more frequently, you're going to obviously want to be able to write those out. I am a fan of taking notes. I mean, even if I've had just a verbal counseling with somebody, I'd like there to be a record somewhere. If for no other reason, then 6 months from now, when I do the performance evaluation, I can look back and say, oh yeah, we did have those 3 verbal discussions about X, Y, and Z. I should include that in the performance evaluation. And it may be in the performance evaluation. I say, we talked about these issues and she addressed them, made the modifications that we needed. That constructive feedback tool, I find to be very helpful. Being objective, we're providing examples as opposed to conclusions. Saying you're performing your job well does not tell the employee. Saying you're not performing up to standards does not tell them anything. Telling them you're late on this project, late on this project, and late on this project, or in these 4 letters that went out to clients, or you embezzled $25,000 from me. Those things are more specific facts. That might be determinable. So keeping those notes are going to help you refresh your recollection as to what were we talking about? What did that happen? If it happens on a repeating occurrence, where I mentioned those, putting something in writing. Again, this is why I don't like the progressive discipline. Is I don't want people to have this impression that you have to give a verbal warning first. If somebody gets into a loud argument with a client, I'm going to take that much more seriously than if somebody maybe gets into an argument with me. When I have the employee, if I'm going to do a written warning, always I want the employee to sign a written warning. This is something that's more serious, requires something other than just a verbal talking to. I'm actually going to give them something. I'm going to put in the file. I want the employee to sign it. I'm not saying, it'll say, I've received this, or I received it and I understand. It doesn't say I agree. And it's very important, because if you try to force them to agree, well, you're going to end up with a battle. If all you're doing is asking them to acknowledge that they received it, number one, if they refuse to sign it, that's insubordination. It's another thing you can write them up for or terminate them. And in fact, the Employment Development Department says if an employee refuses to sign something, that can be considered insubordination, misconduct, and they wouldn't even get unemployment insurance. So they're at least confirming if they received it. And then be clear on what's going to happen going forward. This is going back to that constructive feedback tool. What are going to be the consequences? What do we expect going forward? Leaves of absence. Again, which laws apply are going to depend on the number of employees that you have. I'm assuming you guys are all going to fall in that top. Most people are going to fall in that top category with only having the paid sick leave, workers' comp, Sarah leave, and victims of crime. But many of you are going to have that second one, the 5 or more employees, where the Pregnancy Disability Leave Act and the disability discrimination claims under FEHA apply, where you have to provide accommodations. Once you start getting into 50 or more, it really starts getting complicated because you can have multiple laws. For example, if you have 5 or more employees and your employee needs time off because she become pregnant, that employee is entitled to up to 4 months of unpaid leave while that employee is disabled as a result of pregnancy. That time runs concurrently with the Federal Family Medical Leave Act, which also allows an employee to take 12 weeks off. But it doesn't run concurrently with the California version of that, such that an employee could take 4 months of pregnancy disability leave and then take another 12 weeks of, and I've had some cases where you mix in workers' compensation in there, you work on paid sick leave, and they can get awfully complicated. As a caution, whenever an employee is asking for time off to work for anything other than, hey, I just want some time off to go hang out, if it has to do with them being sick, their children being sick, them having any kind of a medical condition, that's time when we need to sit back. We got to figure out, okay, which one of these laws are going to apply to us? And you may need to, look in your handbook. You may need to do some research. You may need to give me a call, or your attorney a call, or your HR rep a call to figure out what do I need to do in these particular situations. A good response when somebody asks you, can I take this time off, is, you know what, I need to think about that, so that you can have the time to go back and think about it. Just saying, no, you can't, is usually a prelude to problems later on. Any kind of a request for an accommodation, whether it's a leave for absence or otherwise, can require you to engage in this interactive process. And as I mentioned, again, if you have less than 5 employees, technically the disability discrimination laws under the Fair Employment Housing Act don't apply. But just the same, particularly because we have this paid sick leave, the paid sick leave can be used for a number of different reasons, not just the employee's own sickness, but also a sickness or illness of their family. There's also what's called kin care, where they may be able to, now they can use all of that for them. But there's things like school suspension leaves. If I have to run into school real quick to take care of my kids, that we need to be aware of. The paid sick leave can also be used if I'm the victim of domestic violence and I need to go to court or go to see a therapist or have a family member who is, that can apply in this situation. And I just provide this as an example of, this is the chart that I use when I'm going through all the different types of leave. And I actually have not updated since we now have the paid sick leave as well. So I am going to have to update it. So this is just an example of all the different types of leaves that you could possibly have to provide. And some of them are protected, some of them aren't. My goal is that if somebody asks for a leave of absence and if for some reason you're inclined to say no, don't just automatically say no. Think about it. Do your homework to see which of the, is this going to be for any of these protected reasons. And you can ask, why do you need the time off? And they should say, preferably you even have a time off request form. Now, again, if you have 1 employee, are you really going to have a time off request form? Probably not. If you have 5 employees, I think you should. If you've got 10, 15 or more employees, absolutely, you should have a time off request form. Particularly now that we have this paid sick leave, so we know, can we use, is this for something that we need to take off of your paid sick? To terminate or not to terminate. We start off talking about everybody has to sign at will. Well, at will means at will. Doesn't that mean I can just fire anybody for no reason at any time? No. It does. It doesn't mean you can fire them for any reason. You can fire them for no reason, but not any reason. You can't fire somebody because of the color of their skin. You can't fire somebody because they're complaining about their wages. And there was a new law that was just passed in California regarding Equal Pay Act, making sure that men and women, maybe they should get paid for the same amount for doing the same job. Brilliant idea. But California statute actually goes a little bit further and actually provides some actual standards upon which to base that. But there's a small portion in there that says you cannot, get back to it. The law for a long time has already been, you cannot require an employee to keep his or her wages confidential. Where some employers say, you may not disclose how much I'm paying you. That's illegal. Labor code says you can't do that. The labor code now is being amended and effective January 1 will go into effect. It says you cannot discipline somebody for inquiring about other people's wages. So now when Joe wants to know how much Sally is making, they have an absolute right to do that and you can't prohibit that. It's one way that they're using to prohibit, to prevent people from secretly paying men higher wages than they're paying women, or Caucasians higher wages than they're paying non-Caucasians, etc. If you fire somebody for no reason, and I've seen people, they get a termination. Why am I being fired? Well, because you're at will. They're going to go see an attorney. They're going to go talk to an attorney because people don't get fired for absolutely no reason. There is a reason. Now, if the reason is an illegal reason, obviously we don't want to use that as a basis for termination. But providing the employees, letting them know, hey, this is why you're being fired, I think is appropriate. It doesn't necessarily mean you're going to put that in writing. Generally speaking, when I terminate somebody, it says you're being fired. This is your last day, or your employment is ending effective this. It doesn't say the reasons why they're being fired. I don't want to get accused of defaming anybody. I don't want to rub it in anybody's nose. I don't want to create evidence. But at the same time, letting the person know that you're being fired because you didn't do your job the way you're supposed to is important. So examples of what I'm going to call risky terminations. There are a couple of hot button items or hot issues that, when the client is telling me, I want to fire this person, and these are the reasons why, it causes me a little bit of concern. I have this one client that's been my client for years. They have a habit of calling me after they've submitted their claim to the Department of Fair Employment and Housing for discrimination, fighting the claim. They've been for years trying to encourage them, if you actually call me before you fired the person, we might be able to identify this and maybe work around it. And finally, I got him. He calls me up and said, Rob, you told me you want me to call you, so I'm doing it. I'm calling you up. I want to fire this employee. Great. Why do you want to fire the employee? Well, he's getting old and he keeps getting injured on the job. We really just, I thanked him. Thank you very much. Thank you very much for calling me, because we can't use those. And so I talked to them a little bit more, and he did have some valid concerns. This person was a truck driver and he kept stepping out of the truck and hurting himself. So I asked him, well, do you have any other positions available? I've got the dispatch job. We're looking for a dispatch person. Well, does that pay differently? No, say pay. Can you do that? I don't know that he's going to want to. Well, why don't you ask it? And he asked the guy, and the guy was, yeah, absolutely. He was tired of driving the truck. He worked for another year and a half for the company as a dispatcher, retired on his own, and we didn't have to respond to a DFEH complaint. Called me before he fired the employee, terminating an employee shortly after the employee complains about the workplace problems. And it could be, there are some complaints are protected, some complaints are not. If I say you're a jerk and I don't like you, that's not protected. If I say you're treating me differently because of the color of my skin, that is protected. It's not against the law to be a jerk, thankfully. Otherwise, I'd probably be in jail by now. But it's, it is against the law to treat people differently based on certain protected characteristics. And now complaining about their wages, specific Labor Code Section 923, that says employees have the right to collectively and even individually complain about their workplace. So we need to be careful that what they're complaining about doesn't fall into one of the protected. A termination during or shortly after a protected leave of absence. Again, I've said, if somebody's asked for time off, you're usually safe with providing them the time off. Doesn't mean you always are going to provide it, but you shouldn't have an automatic no. But firing in right after they get back from their pregnancy leave doesn't help. I had a client that, again, was doing a reorganization. And they talked to this employee about doing this reorganization. They were going to take this one position and create two positions, and she was going to be allowed to apply to one of them. Shortly, 3 months after that discussion, which was never put in writing, she announced that she was pregnant. She needed to go on pregnancy leave. Okay. Well, her pregnancy leave was going to fall right in the middle of when they were going to be doing this reorganization. Now, thankfully, there actually were board minutes where they had discussions about the fact that they were going to be making this reorganization prior to. It would have been nice if they'd had something in writing to that specific employee, letting her know we were going to do this reorganization. But it did cause some problems, and no amount of energy was spent. A lot of energy was spent trying to resolve that, because pregnancy leave, she's guaranteed her job back, and there was no job to put on. Terminating an employee for poor work performance shortly after giving the employee a great review. That could be problematic. If you're just doing a pro forma review and you're just marking everything as, oh, you're all fives, you're great, and then now you want to fire the person because they're not performing well, there's going to be a disconnect, and that employee is going to think they're treated unfairly, and they're going to start thinking, well, what are the other reasons? It can't be because of my performance. They just said I was doing well. Terminating the employee after they suffer a workplace injury, the workers' comp has some of the higher protections. You cannot discriminate or otherwise threaten or otherwise discharge an employee because the employee has filed a workers' comp claim or made known their intention to file a workers' comp claim. Now, those types of claims go through the workers' comp arena, and it's not a very good arena for employees to go through. But it is also something that is not covered by our workers' compensation insurance, which means you have to hire somebody like me to defend the case. So if somebody needs time off of work because they've suffered a workplace injury, that's one of those keys that, okay, maybe we shouldn't jump in and fire this person right away. I'm telling an employee that you're eliminating the position and then putting up a announcement for their exact same position is going to cause that person, because keep in mind, if you're firing that person, they're going to start looking for another job. And when they're looking on Craigslist and find the advertisement for their job as their place, they're going to think that there is something untoward. So, and that goes, I recommend being honest with employees. I mean, if it is, look, you're just not working out because I don't like your attitude, I'd rather you say that than say, we're going to do a job restructure when you're not really doing a job restructure. The reason you use a certain keywords, harassment, disability, discrimination, abusive, unfair, those are kind of keywords that, would cause me to inquire further. So what were they really complaining about? When an employee sends the email up, I'm tired of you harassing me, because you sit down, you have a conversation with them, try to get them to perform, and then they send an email, you're harassing me, and now you want to discipline them, we may have a problem. That's why when you're having that original discussion with them about their poor performance, if we already have that in documentation, that's documented before her complaint of harassment or his complaint of harassment, it helps to alleviate some of the potential risks. Or having some time in between when that employee is complaining and when you're taking the disciplinary action. Now, that may not be possible because sometimes you have an employee that complains all the time and you're never going to have any time in between. And you may need to address that, figure out what can we change in the work environment that's going to modify that this person's obviously miserable coming into work. When the employee has an intimate personal relationship with another coworker, particularly if that relationship has recently ended, but even if it hasn't, it's difficult to prohibit all work relationships. We spend most of our waking hours at work. It's normal for relationships to develop, but I discourage employees from having intimate relations if possible. Certainly never in a subordinate managerial role. You don't want a supervisor managing somebody that they're having an intimate relationship with. You as the owner of the company or the person who's running the company should never have an intimate relationship with your employees, because there's going to be a problem. And when there is, what do? How do you fire the person when we've just recently broken up and there's this relationship? Also, if you're firing the sister, but you're keeping the other sister still employed, what's that going to do to your relationship with the existing person? Sometimes it's not going to be a big deal, but it is something that is on my radar. And if an employee has recently disclosed that they have a medical condition or they're using medication, sometimes employees share much more information than I want them to. When the employee comes in and says, oh, my doctor, now they've got me on 5 different medications. I got the high blood pressure, I've got this, and I've got that, and the anti-anxiety pills and all these other things. And you see her acting more and more erratic. The fact that she's on this medication is an indication that she may have a disability. And now if you want to discipline him or her, the employee may think, oh, it's because I have this medical condition. So what are some of the ways that we can lower the risk? Number one, for that documentation of performance and misconduct issues when they occur. We're following my rules and we're providing that documentation as we're going. It helps us out. Allowing sufficient time between the protected activity and the disciplinary action. That doesn't mean you should ignore something. If an employee complains about, I think you should be paying me more, and then the next week they're throwing a stapler at somebody, you're not going to wait. You're going to talk to that person. You're going to address that at the time. But it may mean that we're not going to fire that employee for being late the third time because they've just complained about, the reason they were late is they had to go to the doctor. Being consistent, again, if the employee thinks that you're treating them fairly, you're much less likely to end up with problems in the first place. But be prepared to make adjustments if you have to. Consistency doesn't mean everything has to be treated the same. We start with consistency, but we're prepared. Okay, this is really, there are different circumstances. Yes, I didn't allow you to take time off last week when you want to go to the beach. I'm giving time off to John because he's got gout. He needs to take the time off work. Probably don't want to tell people he has gout, but you may treat different situations different. And again, don't make up a reason for a termination. People can usually tell when you're being dishonest with it. If you're going to just make up a story that, oh, we're eliminating the position, and then you're refilling it, you're going to wind up with a problem. Remain professional all the time. So I don't care if they're yelling, if they're screaming, if they're unreasonable, if they're acting like 12-year-old boys. And I have two 12-year-old boys, so I have a lot of experience with that. You have to remain the professional. You talk in the calm voice. If it means you have to excuse that person until they can calm down, that's what you do. You are saying less. You've got your little script of what you're going to say. You're saying you don't have to go into a long speech. As I've been talking to you for an hour and a half about long speeches. The golden rule, I use this all the time. Treat others the way you want to be treated. It's not the way my kids say, which is treat people the way they treated you. No, that's not how it's. Treat them the way you want to be treated. You show them the respect. And finally, pay the final wages on time. When you fire somebody, you have to pay them that day. If they quit, you have 72 hours to get them their check. So if there is a disciplinary issue and you need to fire somebody right away, we got to get rid of you. You either need to get that check ready or you need to continue to pay them. You can fire them and say, look, I'm firing you. Today's Monday. I'm firing you. Your last day is Friday. You don't need to come into work the rest of the week. And you pay them for the rest of the week. Other alternatives are you call up your payroll people and you say, hey, this person's leaving. This is how much they worked. What do I need to write? You write out a manual check. You write out what the deductions are on a separate piece of paper and you pay that. You cannot make payment of final wages contingent on return of equipment. And that's true. You cannot. So you pay them and you tell them you have to return equipment. I like it when they sign it and yes, I have returned it. If they haven't, then we can say, look, you still have our keys. If you don't return them, I have to report that to the police as stolen property. That's usually enough to get them to return stuff. If an employee arrives to work on the drug, you believe under the influence of drugs or alcohol, what are you allowed to do? Absolutely, you can send them home. Now, I wouldn't recommend sending them home in their car if you think they're inebriated. But you absolutely, number one, I'd like to have a drug and alcohol policy that minimum says you can't come to work drunk or under the influence of drugs or alcohol. You want to stick with observable behavior. You're drunk is a conclusion. And observable behavior is you're slurring your words and you smell like alcohol and you got a fifth of Jack hanging out of your pocket. Those are observable. It's not appropriate. You're not allowed to be here at work. You're going home. And then you have to decide, do you want to take other disciplinary action? Do you want to suspend the person or possibly even terminate? Any other questions? Thank you very much.